Trump's 10 biggest lawsuits and the lessons they teach about protecting wealth. That's exactly what we're diving into today. And these aren't political takes. They're real courtroom battles worth hundreds of millions of dollars. And each one reveals a wealth protection lesson that every successful person should know. Because if a man with entire legal teams, accountants, and global assets can still get hit with massive judgments, what chance does the average millionaire have without them? I'm Kevin, the business guy, the CEO of the Lawyers Limited law firm and asset protection planners. And for 34 years, I've been protecting clients from lawsuits. And for nearly 30 years, I've set up Cook Islands trusts more than any firm in the world. And if you want to keep what you've built, subscribe now and visit assetprotectionplanners.com for a lot more free information and when you're ready to make it lawsuit proof. Now here's the plan. We'll cover 10 major cases, what happened, and the tactical lessons for business owners and real estate investors in the $10 to $20 million range. I'll also show how we structure a Cook Islands trust with the Cook Islands LLC inside. You stay the manager when the seas are calm, and our licensed bonded trustee company law firm only steps in when litigation hits. And yes, I'll drop a few cliffhangers because some of the biggest legal twists happen after the verdict. Case number 1, the writer E. Jean Carroll sued for defamation. A later suit added battery under New York's Adult Survivors Act. Juries awarded $5 million in one case and $83.3 million in another, for a combined $88.3 million in damages. In 2025, a federal appeals court upheld the $83.3 million judgment. Risk exposed, words can cost fortune. Defamation can carry massive punitive damages, and appeals don't always erase the bill. Lesson: high visibility leaders need policy and structure, media protocols, legal review of public statement, umbrella insurance, and crucially, assets lawfully insulated from judgment collection. Here's an action. If you're a founder who posts daily, put your personal liquidity in legal moats. That way, if a judgment comes, your bank accounts and brokerage assets aren't the low-hanging fruit. Okay, cliffhanger number 1, can a civil judgment this large really be blocked from collection? We'll answer that when we reach the Cook Island structure and show how control shifts when needed. Case number 2. After a non-jury trial in 2023 and 2024, the court found liability for financial fraud tied to asset valuation. In February 2024, the judge ordered $355 million in disgorgement plus interest, over $450 million total at the time. In August 2025, a New York appellate court upheld liability but voided the massive monetary penalty as an excessive fine. So some injunctive oversight measures remain. Risk exposed, even if you win on money, injunctions and monitors can restrict how your companies operate, borrow, or lead. Litigation can also freeze flexibility right when you need it. Lesson: don't rely on all win on appeal. Your plan should assume years of legal turbulence. So keep operating capital and long-term holdings in separate, insulated rooms legally. Action: segregate cash flow businesses from investment holdings. Build non-U.S. firewalls for liquid assets. Maintain clean lender files and independent valuations. Case number 3, Trump University settlement, 2018. The case: students alleged deceptive marketing. A judge finalized a $25 million settlement in 2018. Risk exposed, seminar education business, and bold promises create class action magnets. Marketing copy can turn into Exhibit A. Lesson: if your company teaches, coaches, or mentors, you need compliance-reviewed claims and tight refund policies aligned with the law. Action: run a claims audit. Keep your liquid reserves outside the operating entity. A class action should not threaten your personal balance sheet. Case number 4, Trump Foundation case. The case: New York AG obtained a court order dissolving the Trump Foundation and $2 million in damages directed to charities, citing misuse of funds. Risk exposed, charity and business must be cleanly separated. Mixing can become personal liability plus reputational harm. Lesson: if you run a foundation, keep independent governance, clear documentation, and avoid political activity with charitable dollars. Action: if philanthropy is part of your brand, put the family investment assets behind a separate shield, not in the same lane as the nonprofit. Case number 5. The Trump Organization, 2 corporate entities, was convicted of 17 counts, receiving the maximum $1.6 million fine. Not a personal conviction, by the way, but highly relevant for owners. Risk exposed, corporate convictions can trigger bank, vendor, and insurer de-risking policies. The fine may be small. The business fallout can be large, however. Lesson: executive perks, payroll practices, and tax benefits must be by the book. Internal controls aren't optional. Action: annual compliance tune-ups, independent CPA sign-offs, and again, keep your personal liquid assets outside the operating company's blast radius. Case number 6. Multiple cases alleged violation of the Constitution's Emoluments clauses. In 2021, the U.S. Supreme Court vacated lower court rulings and dismissed the cases as moot when the term ended. Risk exposed, even dismissed cases burn time, money, and attention and drive headlines that can spook lenders or partners. Lesson: visibility invites legal theory. If you hold public office, own brands, or are a public figure, assume constant legal scrutiny. Action: house critical liquid assets in judgment-resistant structures early. Even no payout cases can distract and delay deals. Case number 7, Trump Towers protesters case. Alleged assault by security. The case: protesters allege that they were assaulted by security outside Trump Tower. The parties settled in 2022 as trial began. Risk exposed, premises liability, and security conduct can roll up to ownership reputationally and financially, even where staff or contractors act. Lesson: tight security protocols, training, and documentation reduce exposure. Your building, your brand, your risk. Action: if you own public-facing property, maintain incident response playbooks, video retention policies, and liability insurance, plus personal wealth outside of domestic reach. Case number 8, condo buyers alleged deceptive sales figures. The case settled in 2011 with buyers reportedly receiving 90% of deposits back, no admission of wrongdoing. Risk exposed, pre-sale marketing stats can be scrutinized as facts, not puffery. Real estate developers face severe class action risk if claims are inflated. Lesson: if you develop or syndicate property, keep third-party verified metrics and avoid aggressive projections in writing. Action: separate development risk LLCs from your personal nest egg and ensure your personal liquidity is offshore shielded where appropriate. Now, case number 9, Panama hotel management battle. In fact, this is the hotel that my wife and I stayed in for our 25th wedding anniversary. And here's the case. A nasty fight over the Trump-branded Panama hotel led to a court-backed eviction of the Trump management team. Signage was removed. Arbitration rulings favor the owners. Risk exposed, franchise management disputes can explode internationally, while local courts and arbitrators control the outcomes. Lesson: when you license your name or manage abroad, the contract, venue, and remedies really matter. Also, foreign fights can move quicker than U.S. litigation. Action: use international risk compartments. One entity for IP, another for management contracts, and keep personal reserves in a jurisdiction with robust asset protection law, which we'll get to in a little bit. Okay, finally, case number 10. Multiple civil suits by officers and lawmakers seek damages related to January 6th. In December of 2023, the D.C. Circuit Court ruled Trump can be sued for acts as a candidate capacity. In 2024 and 2025, district court judges allowed matters to proceed despite criminal case timing. litigation and immunity issues are ongoing. Risk exposed, long-running civil exposure can outlast election cycles, leadership transitions, and even other cases. The legal matters keep running. Lesson: time is a weapon. Plaintiffs can survive motions, shift theories, and keep discovery pressure high for years. Action: build a durable defense posture. Litigation reserves outside plaintiff-friendly jurisdictions, document retention and counsel coordination, and prepositions asset sheet that don't depend on winning early motions. Now here's a bonus case: Trump versus New York Times and Mary Trump. The case: a New York court dismissed Trump's claims against the New York Times and ordered him to pay $392,638 in their legal fees. Related claims against Nice continued separately. In 2024-2025, courts reiterated the dismissal and fees. Separately, another Times suit in federal court was later tossed with harsh judicial criticism. Risk-exposed, anti-SLAPP fee-shifting statutes can turn your lawsuit into their bill. Lesson: when suing media or critics, weigh the fee shift risk. If you're a public figure, and many entrepreneurs are in their niche, the First Amendment bar is very high. Action: keep reputation management and crisis PR strategies ready, and keep personal liquidity where fee judgments can't easily reach. Okay, so the structure that survives the storm, answering the cliffhanger, you've heard the numbers: $25 million settlements, judgments swinging at 8 and 9 figures, injunctions, monitors, and years of appeal. So back to the big question: can you build a plan that even if you lose, your core wealth survives? And the answer: yes, if you start early. And here's the structure that's protected countless high net worth clients, and that is the Cook Islands Asset Protection Trust. It sits at the top. The Cook Islands has the strongest debtor protection case law in the world. Its courts don't recognize U.S. judgments. Plaintiffs must relitigate under Cook Island standards, which are extremely high. And timing matters. Set it up before trouble starts. The Cook Islands LLC right here, this is inside the trust. In other words, the trust owns the LLC, and you over here are the manager when things are calm. Investing, banking, moving assets, and so on, you're in the driver's seat. When litigation hits, our licensed bonded trustee company law firm, right up here, they're the ones who can step in to protect you. They can run interference, and they do it only when needed to follow court-tested protective protocols that keep assets out of hostile reach while staying within the law. In other words, U.S. courts don't have jurisdiction over our Cook Islands law firm trustee, and your money stays safe and secure. Okay, now, domestic operating entities stay separate. In other words, your business keeps running, but liquid assets, brokerage accounts, and cash reserves live outside that domestic blast radius. So you put the liquid assets, the bulk of the liquid assets, in your Cook Islands Trust. For U.S. real estate, we don't typically move titles offshore. Instead, we use equity stripping, a recorded line of credit mortgage payable initially to the LLC that's inside the trust. And then if needed, we get a third-party lender to buy that lien and then put the proceeds from that lien into your offshore trust. So we have a third-party lender that has a lien on your property, and then the cash from those proceeds go into your Cook Islands Trust. So your property over here is totally encumbered, and the proceeds from it sit outside the jurisdiction where the U.S. can grab it. So the goal is simple: nothing easy to take. Okay, now let's resolve cliffhanger number 2, but what if a court orders me to bring the assets back? And that's the point of the jurisdiction. A U.S. court order doesn't control a Cook Islands trustee. The trustee follows Cook Islands law and acts to protect you only when necessary. So this is why wealthy families set it up way before lawsuits appear. Practical playbook so you don't learn the hard way. Separate silos. One entity right here for operations, to operate your business, to do business with the clients, sign contracts, and another for intellectual property down here. So this holds the intellectual property, and this company simply leases the IP, the brands, the copyrights, and so on from the IP holding company. So the one that has the liability, the one that can get sued by the customers here, doesn't have a whole bunch of cash in it. Your operating company has very, very little cash, and you don't let a single plaintiff hold your whole net worth hostage. The business up here also, and you set up a holding company that holds one that holds real estate, another that holds equipment. Your operating company leases that equipment. Again, the whole purpose is this operating company has very little to nothing to take. So the key thing is you want to document like your net worth depends on it, because it does. Valuations, board minutes, compliance checks. Dull paperwork beats a flashy verdict. Insurance is the seatbelt, not an armored tank. So you use it, but don't rely on it for catastrophic legal risk. And we see it in our law firm time and time again. People thought insurance would take care of things, and an exception in the policy or the policy limits don't kick in, and they have to pull money out of their own pockets. So never delay setup. The best time to build the firewalls is before the smoke. After papers are served, options shrink, things get more expensive, and courts get suspicious. So think globally. Laws differ. The Cook Islands gives you law that doesn't bend to a domestic judge's pen. Okay, here are the short case-by-case takeaways lightning round. Carroll judgment. Public statements can cost more than business mistakes. New York civil fraud. You can win on the money and still live under injunctions and monitors. Plan for years of turbulence. Trump University. Marketing claims equals legal exhibit. Audit your promises. Trump Foundation. Charity must be squeaky clean. Keep it walled off. Organizational tax conviction. The fine is small. The reputational hit is huge. Emoluments. Even a moot case can cost years. Shield liquidity early. Protester settlement. Premises plus security conduct equals your brand risk. Train and document. Trump Soho. Verified sales data beats glossy brochures. Third-party validation. Panama Hotel, where my wife and I stayed. Abroad, the venture is the game. Contract and jurisdiction strategy. January 6th civil. Immunity fights don't stop discovery clocks. Plan for the long haul. If you're sitting on $1 to $20 million plus in real estate, business equity, or liquid assets, and you want a calm seas manager, storm seas trustee structure that's been battle tested for decades, talk to us at assetprotectionplanners.com. My team builds this every day of the week for business owners just like you. So I got into this field because I watched good people lose decades of work in months, not because they were bad people, but because lawsuits move faster than life. I mean, the names change, the headlines change, but the playbook stays the same. Structure first, and then sleep at night. Subscribe so we can see each other again. This is The Business Guy.